Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that the panel, if we have additional questions past the time you've been allotted, will ask them, and you'll have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Manuel Lebron. Submitted. Wallace v. Cheng. Submitted. V. Hanna is submitted. Martinez v. Bronx County Historical Society. How much time do you want? 10 minutes. Do you want to divide it up with some rebuttal time as well? How about yourself? 5 and 2 and 5 and 2. Thank you. Salas v. 711, 715 East 23rd Street.
Third party defendant appellant request 5 and 2, please.
For the respondent, Thomas Thornback, request 5 minutes.
5 and 2 and 5. Avail Holding v. ICM Funding.
Respondent, 3 minutes.
Right, your opponent's not here. You'd still like to address the court?
3 minutes, only to answer any questions.
3 minutes. Beauchamp v. New York City Transit.
Good afternoon, defendant appellant, request 5 and 2, please.
Plaintiff responded, request 10 minutes.
I'm going to give you 6 and 2 and 6. Gibraltar Contracting v. Tully Construction. Submitted. Gutierrez v. 80 Winthrop Street Owners.
Appellant, 80 Winthrop Street, 5 and 2.
Just 3?
Respondent, 5 minutes, please.
Okay, 5 and 2, 3 and 5. People ex-rel McGee.
Good afternoon, Your Honor. Respondent request 5.
5 and 2 and 5. S. Natasha v. Joseph B. Submitted. Slovakis v. Poyagis. 3 and 4 and 3. Matter of Bulgari. 6 and 2 and 5. People v. Pedro Falcon. Falcon, submitted. ARK 448 Doe v. Mary Knoll. Yeah, sorry. Okay. 5 and 2? 5 and 3, okay. Counsel?
Good afternoon, Lucky Elise, Wilson Bay, Conway, Cousins, for the defendant respondent, 5 please.
5 and 2 and 5. Last case heard v. Moore is on submission. First case up is Martinez v. Bronx County Historical Society. Please.
May it please the court, I'd like to use my time to focus on the appellee's reply brief and to answer three of the points that it raised. All relate to whether Bronx County
Counsel, put the microphone a little closer to yourself. Thank you.
Sorry, of course. All relate to whether Bronx County Historical Society could receive credits towards any minimum wage that's found to be owed based on the free rent and free utilities that Mr. Martinez enjoyed for the 7 years that he was the caretaker at Poe Cottage. The appellee makes three arguments in its reply. First, that no credit should be applied because Bronx County Historical Society never told him that such credits were being taken.
You told him
Second,
what?
Never told him that such credits were being taken against
Well, but
wages.
that doesn't determine your obligations as a matter of law, does it?
No,
you
we
told
say,
him?
we say we have no obligation under the law because we are not an employer in the first instance.
If we were to find you were an employer, do you agree that he should be given credit for the, his non-pecuniary remuneration?
I think that if you find that we are an employer and he is our employee, that consequently he would, like any other employee, be entitled to be paid at the minimum wage. The question, though, is whether or not the 7 years that he lived here.
No, I understand that's
Yeah.
the question, but if we found that, you would agree that he should be paid at the minimum wage?
Absolutely, because I'm an employer and he's an employee, and that's what the New
And
York
do you
labor law
get,
says.
do you think that you should get a credit against that for whatever the value is of his non-monetary compensation?
Yes, that's what the lower court held, and
I
that's
understand it's
wage
what the
order
lower court held, but you didn't ask for that, did you?
asked for the credit.
Yes.
Didn't ask for the credit because there hasn't been a trial. This is one of the points.
I
that-
understand that, but one can plead in the alternative. You didn't plead that in the alternative, correct?
Specifically that we're entitled to the credits?
Yes.
We didn't plead it. It was part of the motion, however.
You argued it in the motion?
Did argue it in the motion, and the lower court essentially granted that request. That's what she sent over to be considered for damages, what offset there should be.
We understand.
Yeah, based on the allowances. So
Why would you not consider yourself an employee?
Claire.
Employer. Sorry.
we're not an employer as it relates to this individual because, as our argument of first impression insists, we are in fact, as related to this individual, a governmental agency.
Now, governmental agency is not defined in the statute, correct?
Correct.
So what attributes do you think you have as a governmental entity?
Well, we have all of the attributes that existed in the Clark-Fitzpatrick decision, which applied to the Long Island Railroad.
But that was for public transportation, and the statute specifically provides that that's considered a governmental agency. You're not in the same bracket.
What we're saying is similar to Clark's Fitzpatrick and even more similar to the Great Neck Park District in the Brown decision, we meet all of the criteria for a governmental agency.
What public function are you carrying out that
Well,
would make you a government agency?
The public function that we're carrying out, as expressed by Bronx County Historical Society, is to provide historical information and significance.
How is that akin to providing transportation for the public? Because that's one of the cases you're relying on.
Well, it's not necessarily a case that I'm relying on for that specific that specific point. I'm relying on that case simply because it addressed the factors that go into the determination as to whether or not an entity is a governmental agency. There, the question was Long Island Railroad. In the Brown decision, the question happened to be regarding Great Neck Park District, and the judge in that case analogized to the New York City Parks Department, which is the owner here through the city of Poe Cottage. So if you align the factors in Clark Fitzpatrick and you align the factors that were examined in Brown, you see a straight line as to why the answer is yes. Bronx County Historical Society, specific to Mr. Martinez's role as the caretaker on this city property, is
Aren't
serving
you-
a governmental function. That is the preservation of this
Counsel,
property.
Justice O'Neill Levy has a question.
I was wondering about the funding. Isn't it predominantly contributions?
No, I don't think that's right. In the record, we talk about the percentage. You can see from their website the amount that comes from the city, directly or indirectly, and then the amounts that come from other sources, such as
Was that the extent of your evidence regarding your funding, allusion to the website?
well, no, the website actually links directly to the tax information that's been filed by them, by Bronx County
Is your
Historical
funding
Society.
from city grants, private grants, donors,
Everything.
everything?
Everything, but a substantial portion is from the city, from tax
What in the
revenue.
record do we have to substantiate that a substantial portion of the funding is from the city?
Well, if you look at the tax forms that are filed, that are available on the website, they link directly back to those tax forms. They show the source of the funding.
I'm sorry, we only rely on what's in the record before us. What you're asking us to look at is not in the record before us, correct?
Well, it is in the record before you to the extent that the record includes the link to the website that itself links back to the public documents. So I
Thank you,
guess,
counsel. You have time in rebuttal.
okay, thank you.
Good afternoon. May it please the court. I'd like to address that first question the court is asking about the status of BCHS.
Counsel, did you give your appearance yet?
Apologies. Russell Adler for the plaintiff, Mr. Martinez. BCHS is a 501c3 not-profit. It is not a public benefit corporation. It is not a special purpose district. As the panel has noted, the cases applying the governmental exception all involve entities whose function is traditionally associated with what the government does: public transportation in the Clark case, the police force in the Hodgkin case, municipal administration in both the Perry and Arcelo
Does
cases.
the source of their funding have anything to, is it, I won't say dispositive, but should we take that into consideration when determining whether or not they are a public entity,
It is not.
mental employee?
It is by no means dispositive, and it is effectively irrelevant here. The Department of Consumer Affairs funds 33 cultural institutions in New York. They include the Museum of Natural History, the Metropolitan Museum, the New York City Ballet, the Bronx Zoo. It would come as a surprise to all the individuals who work there that they are not employees and not protected by the law. The theory espoused by BCHS here would effectively allow any party in privity with the government to claim to disabuse itself of employer status. That is not the law, and there is no authority extending the government entity that far.
Do you concede with your adversary's point that their information about their funding is in the record vis-a-vis this link to a website?
I'm not aware of anything in the record that would support that, and counsel already represented that they have funding sources from multiple streams, both donors, the government, and otherwise.
And what's actually in the record is that we have no way of really deciphering where the majority of the funding comes from, correct?
That is correct, Your Honor. I'd next like to address the point that counsel raised about the credit for minimum wages. BCHS is not entitled to take any credit against Mr. Martinez's minimum wage because
Why wouldn't they be entitled to credit if they've been providing him a place to reside for these past 7 years?
And utilities?
Yes, two reasons, Your Honors. First, it failed to plead as an affirmative defense. It's not in the record. It was never raised until this motion. Secondly, it didn't comply with the statutory notice and record-creeping prerequisites, which this court has held are mandatory. Section 195 of the labor law says that written notice of all allowances, if any, claimed, including tip, meal, and lodging allowances, must be given upon hire. They were not given. Similarly, the minimum wage order
What
requires
about
that
the fact that they indicated this was the compensation, is to live there and get the utilities paid?
that argument would be then asking him to waive his statutory rights. And New York Labor Law 663 says you cannot agree to accept less than minimum wage. So effectively, they're asking him to waive his rights by acknowledging, by the way, that he was a volunteer, which was the original position they took below. They've abandoned that argument and now taken on this governmental entity exception. I would ask that, so there's no notice given to Mr. Martinez of this. They also say that equity should allow them relief here, but the court is very clear from the Court of Appeals that courts may not relieve a litigant of a positive statutory mandate, even if it were to avoid a harsh result. I would add, there is no harsh result here. Mr. Martinez was unpaid for several years before he brought this action. time that he lost forever due to the statute of limitations. If there's equitable benefit here, equitable consideration, it certainly did flow to Mr. Martinez, who was duped into taking
Counsel, I'm
less
sorry, you
pay.
got to unpack that for me. I don't understand what you just said. You're saying because he has to adhere to the statute of limitations that we should forget about the fact that he got free lodging?
No, I'm not saying that, Your Honor. I'm
Okay, I
saying that
misunderstood.
in the concept of equity, so he is not, BCHS cannot be relieved of its statutory mandates by equity. Period, stop. That's what the Court of Appeals has said. But I was just adding as a notion of, if you consider the equities here, Mr. Martinez worked unpaid for about 3 years. Then when he was finally paid, he was paid in part for only 10 of his 27 hours. So if there's anybody who deserves equitable consideration, it would be him.
Okay, please continue. Anything else? You have time to rebuttal. I'm not asking for anything. I just want to make sure.
Certainly, I would just add that on the issue of liquidated damages, I want to just point out that this court requires that the party, to avail itself of, to avoid liquidated damages, you must show good faith. And that requires taking active steps, that's the word, from Vega Court, this court, Your Honor, that they try to discern the boundaries of the law. There is no evidence of good faith taken in this case, and in fact, they did not do research, did not consult with professionals, did not speak to an attorney, did not contact or review regulations. And in fact, their justification for the manner in which they treated Mr. Martinez as a non-paid employee was that's how it was done. That is not defense. Thank you.
Please. Okay, thank you, counsel.
Very briefly, just on those points, the question of whether there's a majority of funding or 27% or 9%, this was not an issue that bothered the Brown Court. They simply, what the judge talked about there was defendants' expenses are largely paid through taxes levied by the town of North Hempstead. And the court goes through analysis simply using
We're not
this-
bound by that court, by decisions of that court in any event.
Understood.
Do you have any case law from any cases from the Court of Appeals or from this court that support your position, apart from the case involving the Long Island Railroad, which, as we've all said, is not necessarily relevant to this case?
Well, those appear to be the only two operative cases here that speak to, and they both speak to whether or not a particular type of corporate entity can be a governmental
So if we
agency.
agreed with you, why wouldn't this apply to all of the other agencies that are funded, excuse me?
Great question.
Excuse
That
me.
was my second-
Excuse
Let her
me.
finish the question, counsel.
That are funded by DCA, including the Museum of Natural History and so on.
Great, I've been champing at the bit to answer that question. And the reason why is because even if the city was not an employer with regard to all of those entities, and they didn't have to pay anyone who worked at any of those entities, good luck finding volunteers, hundreds if not thousands of volunteers. This case is unique because it applies to perhaps 30 or so different caretakers at these historic homes.
I'm not following your reasoning. What are you saying? Good luck finding volunteers. What does that
What I'm
mean?
saying is this is a situation that is distinct because all of the other people that work for the Met or the Brooklyn Museum or anyone else, they are paid by the city to the extent they are city employees.
But
I
if,
think the
but if
que-
you were to pay this person and also provide him with free rent and utilities as part of his or her compensation, you would also find enough people to fill the void, to fill these positions.
I guess I don't know the answer as to whether we can say with certainty
Mm.
that if the city said every one of these positions is an unpaid position, but will only accept volunteers, and we're not providing free housing, and we're not providing free utilities, I don't know that you'd be able to staff those.
Didn't your
those
agency pay
agencies.
former individuals in this position?
I'm sorry, I didn't hear the beginning.
Didn't the Poe Cottage pay individuals that had this position in the past?
Not with regard to the caretaker, where it was providing, the caretaker was providing the services to HHT, providing the services to the Parks Department, providing those services to New York City. You have a straight line from New York City to Poe Cottage to Mr. Martinez. You do not have a straight line between the other BCHS employees who were not performing services for the city's property. They were performing services for Bronx County Historical Society.
Can you explain how the 501c3 status intersects with the governmental agency?
Yeah, it doesn't, and it doesn't have to, because Clark Fitzpatrick talked about the Long Island Railroad Great Neck Park District talked about a different type of entity, but neither of those decisions said, well, you have to be one of those in order to be a governmental agency. So this is something the lower court never actually conducted any of that analysis, sort of fell for that concept. No one has ever said that a 501c3 cannot be a governmental agency if it is providing the same type of services that, in this case, were provided by the plaintiff in
Thank you, counsel.
the Great Neck Park District case. Thank you very much.
Briefly, Your Honors. Justice Michael, you are correct. The prior caretaker was paid, and that the fact that he was paid was what triggered Mr. Martinez to inquire, why wasn't I being paid? I would add, to the extent that the city is relevant, BCHS brought a third-party action against Historic Housing Trust, and that was dismissed without appeal. And lastly, I would argue that the expansion there that BCHS is suggesting to the court would certainly require legislation. This is not something that can be done by just a judicial decision that would effectively change the status of tens of thousands of employees amongst the most important cultural institutions that this city has. I have nothing further. Thank you, Your Honors.
Counsel, thank you both. Salas v. 711-715 East 231st Street. Please.
Good afternoon, Your Honors. Jillian Rosen for the third-party defendant appellants. I'm sure you've all seen the video in this case. Right, so we're not here. The issue before this court is not the video. The issue before this court is whether the third-party complaint sufficiently alleges and makes out or provides sufficient factual detail to support the causes of action that's set forth.
Why don't we start with Judiciary Law 47?
Sure. Well, as we know, Judiciary Law 47 requires deceit, specific facts showing a knowing intent or intent to mislead and deceive. It's very serious.
Is your understanding of the allegations that they contend satisfy that pleading is that they contacted the lawyer and told the lawyer that this case was fraudulent?
Is that my understanding of their?
Yes.
I don't really think that they make out any. It's entirely insufficient because what happened, the reason why this doesn't support Judiciary Law 47 is because once the video from their building was exchanged with Mr. Roitblatt.
When did that happen? I'm sorry to interrupt.
No worries. It's not clear exactly from the record when that happened, but the letter that Mr. Roitblatt wrote to the court in June of 2024, which is at 123 of the record, indicates that he recently received evidence, didn't specifically say a video, that there may be fraudulent conduct that required him to be extricated from the case, and he submitted a unilateral stipulation of discontinuance to get himself out of the case. That was 4 months.
There was communication between the parties starting in March, right?
Yes, well, in fact, even earlier. Well, I mean, he commenced suit for the Salas suit in February, and then from February to April, they exchanged discovery, and that was based on what Mr. Roitblatt says in his motion to dismiss the third-party complaint, that he engaged in discovery based on what his client told him. And then 4 months later, in June, he learned about the video, which obviously is nefarious, and he wrote a letter to the court, 123 of the record. And interestingly, if you look at the record, at 123, he specifically says, "We've been apprised of underlying facts purporting to display actions taken by plaintiff at the direction or behest of the plaintiff, which may well be interpreted as fraud or misrepresentation, prevents the undersigned firm from proceeding further in good faith."
So the delay in bringing this to the court's attention, does that somehow satisfy a pleading with regard to the judiciary law?
No, because I don't think there was any delay. The delay.
February to June?
I'm sorry?
February to June?
Well, no, February is when he commenced suit on behalf of Salas.
But the allegation in the complaint is that in February, the defendant's counsel exposed to them informed Roitblatt that the claim was fraudulent and that there was video evidence demonstrating the third-party defendant, Pena, manufactured the defect in the photograph and that plaintiff faked his trip and fall. That's in paragraph 125 of the complaint.
Right,
So why isn't that sufficiently specific?
because it doesn't establish what they did to provide Mr. Roitblatt with that information. It's
It
just
says that the counsel contacted him and told him that.
well, Roitblatt writes in his affirmation in support that I didn't learn about this until June, or just
Well,
prior
I
to
think
June.
it's,
I'm sorry, go ahead.
I was just going to say that the complaint says that then they were notified that ABC News was coming, and it was after being notified that ABC News was going to air a story on this.
Right. Well, Mr. Roitblatt, in his affirmation, sets forth that in his letter to the court says we've recently learned that there was exposed fraud, or there was an element of fraud here, and he looked to be relieved as counsel. Actually, he submitted a unilateral stipulation of discontinuance, and then he tried to get out of the
This is a
case.
motion to dismiss, so we don't look at his affirmation, we look at the complaint only.
Well, there's a
In
heightened
the
pleading.
basis of the complaint, I'm sorry, in the complaint, counsel for defendants alleges that he told Mr. Roitblatt that it was a faked accident. So why isn't that enough?
Because our position is that within a couple months, he then wrote.
That's February to June.
Well, that's our client. My client doesn't.
I understand your client denies it, but the point is, it's a motion to dismiss. So if we have to take the allegations in the complaint as pleaded, why isn't it sufficient that defendant's counsel alleges that he told Mr. Roitblatt in February that the accident was faked?
Because Mr. Roitblatt, just based on the news or coverage of the news isn't sufficient. He wrote a letter to the court saying, I've learned that there was fraud, and I'm trying to extricate myself from the case.
The judiciary law requires a heightened pleading standard, correct?
It does. It requires an intent to deceive, and I think that his...
And that's what you're essentially arguing, is based on his conduct, there was no intent to deceive,
Right.
or no allegation that there was an intent to.
That's right. I think right. Our position is that his action to be relieved as counsel, and he was relieved as counsel, to get out of the case once he learned.
But what
of
my
it.
colleagues are arguing, right, is because it's a motion to dismiss, right? We just look at the allegations alone. We're not looking at what your client did. So if we look at the allegations alone, how do those allegations in the complaint not rise to the level of establishing this intent to deceive, this heightened standard?
Because the allegations don't allege anything that he did, that he knew about it when he commenced the Salas suit.
So,
All it's-
counsel,
Sorry.
they allege that they notified Mr. Roitblatt in February that this action may be fraudulent, and that instead of immediately, in essence, extricating himself from the case, he continued to litigate. That's the allegation in the third-party complaint. And he continued to litigate because he served a verified bill of particulars. He served, he responded to notices of discovery and inspection. And in addition, he submitted an affidavit from a investigator, which was Mr. Pena, in essence, that was also fraudulent. So the fact that instead of extricating himself immediately in February, he submitted that verified bill of particulars and responded to the discovery and inspection and submitted that affidavit from Mr. Pena. They allege do you agree with them that that would be sufficient?
I don't agree with them.
Why?
Because it's not an intent to deceive if you're doing what he did in just before June. It's a couple months, and his position was that he learned just before the letter. So that's why.
But you keep ignoring the statement in the complaint that plaintiff defendant's counsel told him in February,
With videos.
and specifically told him about the video. So how can you, if you assume given that that allegation is in the complaint, how do you justify the delay until June?
Well, because with the affirmation that my client submitted under oath, right,
We don't
says he
consider
just learned
I'm
of it.
sorry, counsel, this is a motion to dismiss, so we don't get to your affirmation. Why doesn't the complaint sufficiently state a claim, given that it alleges The defendant's counsel told him that in February, and he did nothing until June.
And with regard to the claim being that there is an allegation of an intent to deceive, how is what they say they did and told your client rises to the level of establishing an intent to deceive?
Because there's nothing specific in the third-party complaint in our position that shows that the Roitblatt defendant firm did anything, whether it was directing them or acting in concert with them or knowledge of this until they received the video. So that's why Judiciary Law 487, our position is they didn't establish the elements of 487. I could take up the rest on reply.
Thank you, counsel.
Okay, thank you.
Good afternoon. Thomas Bundock for the respondents. I think the court has asked the right questions of counsel, and I think that counsel has made a good argument for perhaps later in the day a summary judgment motion, assuming the discovery that takes place does not reveal sufficient acts to establish.
Counsel, how does what you alleged about what your client did establish a claim for the third-party defendant having this intent to deceive, the heightened standard under the judiciary law?
It is a heightened standard, but the third-party complaint has several allegations against Mr. Roitblatt. Not just that he only tried to relieve himself of, as counsel after the news media got wind of the fraudulent claim. The third-party complaint alleges...
Do you allege when he received actual information about the fraudulent claim?
It is alleged in the complaint that Mr. Pena, Wilson Pena, the individual who was videotaped creating the sidewalk...
We know who he is, yeah.
Okay. So it is alleged in the complaint that Mr. Pena was a runner of the Roitblatt law firm, that Mr. Roitblatt knew that Mr. Pena was a runner, that Mr.
How does that...
Oh, I'm sorry.
I mean, you could keep talking if you want to.
That's okay.
How does that inure to the third-party defendant, what Mr. Pena was running? How does that establish that that there was this intent to deceive, that he knew that he was creating fake defects?
The third-party complaint alleges sufficient detail for the court, for anyone to see that there is an inference of knowledge. He has the third-party complaints, the allegations in the third-party complaint are the only things that are before the court, not whether or not Mr. Roitblatt is guilty.
No, I understand that, but what in the third-party complaint do you allege establishes or even alleges knowledge? Not knowledge of him being a runner, right? Knowledge of him being this person who created, and when I say person, Mr. Pena having created these fake defects, which they then sued upon.
Yep. And that Mr. Roitblatt knew that this particular matter that he was involved with was faked, was somehow staged.
It is alleged in the third-party complaint in paragraph 20 on page 26 of the record that Roitblatt Law and Roitblatt directed and compensated Pena as a runner to locate or recruit clients or manufacture a defect and stage an accident.
That's all conclusory.
That is, those are allegations in a third-party complaint that have to be considered as true for purposes of determining whether or not the pleading is sufficiently alleges a fraud and alleges a violation of Judiciary Law 487.
Counsel, in paragraph 120, I'm reading, third-party defendants were aware that Pena created the condition on September 12th, 2023.
Well, I hadn't completed the several paragraphs that allege the actions of Mr. Roitblatt.
That would be one, though, right?
That would be one of them. So the pleading itself,
But it can't be conclusory, right? Because it's a heightened pleading standard for both these claims.
I think to suggest that we have to put our proof before the court.
Nope, but you have to put something that is a bit more than mere conclusions, and you have to substantiate it because of the nature of the cause of action that you're alleging.
We have made an allegation against Mr. Roitblatt that he recruited Pena, that Pena was a runner for his firm, that he directed Pena, that Pena created the defect, that Pena recruited Salas, that Mr. Roitblatt knew this, that Mr. Roitblatt verified a pleading. I think I'm out of time, but I wish I could go on.
Please finish the thought.
All right. So the allegations in the complaint are very detailed, particularly with respect to Mr. Roitblatt. They allege that he hired Pena as a runner for his firm, that he directed Pena, that Pena created the defect, recruited Salas, that he verified a pleading, that he had his notary in his firm, Brent Schimmel, falsify or notarize a false affidavit.
But that notary, is he attesting to the content of the affidavit or to the identity of the person that is signing the affidavit?
Well, the allegation is that he knew that when he notarized it, that it was false.
You see where we're going with the conclusory language? That's the allegation. But how do we know that Mr. Roitblatt knew that this accident, that this incident, that this matter was staged?
The proof is in the pudding, and the pudding is in discovery. And discovery takes place when depositions occur, when disclosure is made, when statements are taken, when non-party witnesses are deposed. All of that occurs during the discovery phase.
If we get there, after we review the pleading.
but we
Thank you,
cannot-
counsel. Thank you very much.
Your Honor, just with regard to 47 for a second, there is no allegation that Roitblatt knew about this when he commenced suit. There's none, zero. They're basing it on a video that just shows Salas and his accomplice doing what they did. There's no evidence that he knew about it. There's no evidence that he directed it, and there's no evidence he acted in concert.
No, I mean, it's not when he commenced the action February 2nd, 2024.
Correct.
Some point in February, he was informed that there was video that showed that this was a fraud. So it's not when he commenced the action, it's rather what did he do after he got that information?
Okay.
But he continued. I guess that's
He-
that's what he continued. He didn't do what we think others might say, I want to see that video. What's going on here? Rather he continued on the case. Maybe he didn't believe it. I don't know. But only when ABC News, he gets alerted, ABC News is going to do a story on this, that he goes to the court.
Well, I mean, that's what they're alleging. That's
I
what,
mean, that's when he
that-
says,
that
okay,
is
we
what
have
they're
discovery
alleging.
to figure this out.
right. And I'd just like to quickly, before my time is up, turn to the fraud cause of action. The fraud cause of action is also as deficient as the 47 cause of action because there's any material misrepresentations that they claim were based on the allegations set forth in the Salas complaint, which, as we know, under 47 and under fraud is not sufficient to support those causes of actions. In addition, with regard to fraud, as this court is well aware, there's no allegation of justifiable reliance and damages, which under a litany of decisions by this court renders the fraud cause of action defunct. I mean, you can't have a justifiable reliance when you're contesting the litigation. So with respect to fraud, our position is that's not made out as well. So 47, our position, there's no intent to deceive, there's no deceitful conduct, and with regard to fraud, they didn't meet the elements. The other three, quickly, just to get to it quickly, is that with regard to conspiracy, there is no standalone. You'd have to tether it to a cause of action that has any sufficient teeth, and here there isn't. So they can't tether it to fraud, which is what they're trying to do with their conspiracy. And with regard to intentional property damage, that's also not recognized by New York. And as you see, the video basically belies any claim they either had knowledge or anything to do with what you see in the video on damaging the defendant's property. So for all those reasons, our position is under 3211A7, the third-party complaint should be dismissed.
Thank you. Counsel.
Thank you.
Thank you both. Avail Holding LLC, DICM funding.
Good afternoon. May it please the court, my name is Rachel Rosenberg. I'm with the law firm of Abrams Fensterman, and I represent respondent Avail Holdings LLC. While I'm aware of the case law in favor of granting pleadings every favorable inference, the circumstances were different here. In fact, the lower court, while not granting sanctions, noted it's concerning that defendants asserted counterclaims which are flatly contradicted by the documentary evidence. This case was always about the fact that ICM...
The documentary evidence you rely on is our emails. What else?
Let's start with the fact that there was a verified answer by the defendants.
I don't find that to be so strong. Have you got a good case law on that? Because, I mean, they have a new answer, obviously, and that's the one we're working from. So what's your best case on that point?
So I do cite to a First Department case in my papers, but I can cite to another First Department case, Carey versus Toy Industries Association. Facts admitted in the complaint constitute formal judicial admissions and are conclusive of facts admitted. And in J-Trend NY...
In
Was
that
there-
case, I'm sorry.
Yeah, go ahead. Go ahead.
In this case, it's different because there was an answer that was later amended to say something very different. So assuming that we're not going to rely on that, because what is your next best piece of evidence?
So in addition to the fact that the first verified answer is verified
Okay,
by
I
Mr.
asked that you not
Savati.
consider that. Could you move on to your next
Yes.
best piece of evidence, please?
There's a holdback agreement here that says if they don't deliver the loans by a certain date, an escrow is released. The escrow was released. They consented to the escrow being released. The principal of the defendant testified that they did not deliver the subject loans.
So you're asking that we consider the testimony as documentary evidence?
Yes.
That's not normally considered documentary evidence.
And that is why I'm up here to as
So
respondent.
what documentary evidence do you have?
The documentary evidence includes the testimony, the depositions,
Assume
and the
that
email. and the-
testimony, obviously they disagree about what they're going to say about the case. So the testimony is not documentary evidence.
But in this case, where there were 18 months of discovery, and after 18 months of discovery, where defendants took the position that they did not deliver these loans, to suddenly in a counterclaim verified by an attorney only and pled upon information and belief ICM did perform under the contract, they don't even plead that they delivered the loans. They failed to state a cause of action. If there are no further questions, I'll rest on my brief.
Thank you, counsel. Beauchamp v. New York City Transit Authority. Please.
Good afternoon, Your Honors. May it please the court. My name is Jennifer Adler, and I am here on behalf of the MT defendants. I am not going to tell you that Ms. Beauchamp did not sustain severe injuries. That's not what I'm here to tell you. But what I am here to dispute is plaintiff's contention that there are no analogous cases in this court.
So that's interesting. I mean, I understand that the issue is what's comparable, but I can't think of any case I've ever heard of in this court that involved, for example, a plaintiff who had her entire lumbosacral plexus ripped from her spinal cord and therefore had no feeling from that in that whole area. Is there any comparable case?
What I did is I separated past pain and suffering and future pain and suffering.
Well,
So-
could you address the question specifically that I
There is
asked? Is there
not-
any case involving that kind of injury?
That specific injury?
Right,
no, I
cutting
have
off
not
nerve endings to half the body?
Any cases in that particular injury.
I didn't hear your answer because you were talking over her.
Oh, I apologize.
That's okay. I just
There
need to
is
hear.
not a single case that addresses a lumbar, the aversion, the avulsion of the lumbar plexus, okay? But there are cases that can be analogized to the case here. For example, for past pain and suffering, there is a case called the steam pipe explosion case, where Miss Kane was blown across the street and buried.
That's a 2017 case, right?
That is a 2017 case, which in this situation is not a really old case. And
Well, I mean, in terms of inflation,
well, in terms of inflation, so the past pain and suffering award in that case was $4.3 million, which this court reduced to $3.25 million. But Miss Kane, who was 70 at the time of that case, was blown across the street. She was buried under rubble and wet, hot condensation for almost an hour, which is longer than the plaintiff here, believing she was dying. Her lower leg, her right foot, was barely attached to her body. Very similar facts of what happened. Deformities, 15 surgeries, muscles and arteries taken from her stomach to rebuild her lower leg, bouts with, an infection and C. diff.
But by the time of trial, she could walk without pain and perform all her daily functions without assistance, correct?
Well, she had a lot of issues with mobility.
Right, but there's nothing comparable to the condition that plaintiff was in this case at the time, by the time of trial.
Which is probably why this court, the future pain and suffering was much lower. It was it was reduced to $1.5 million. But she had a lot of issues even at the time of trial.
well, it said she could walk for an hour and no longer take prescription pain medication. So that's different already, right?
That is different already, absolutely. But there were a lot of limitations. She had tried to go visit her family in Virginia, and she had to be lifted up by the conductor to get onto the train. She had a lot of issues. She fell down at stairs. Her mobility was not well. And I'm not by any means taking any of Ms. Beaucamp's pain and suffering away.
Well, we understand that, but the nature of what we have to do, because you're down here on appeal, is we have to find cases that are comparable and line them up to see what is a reasonable award. So you do have to, put apples to apples, not apples to oranges, right?
I understand. I understand. But the cases that plaintiff has cited in their brief, if you're trying to go apples to apples and oranges to oranges, are certainly not comparable.
So what about the Kurtaj case, where this court reduced an award so that the plaintiff's pain and award for 3 hours of pain and suffering was $7.5 million. In some ways, the pain and suffering in that case was most analogous to this, but it went on for 7 years, as opposed to 3 hours. So why isn't that a good measure for us to measure the past pain and suffering by?
Well, Kurtag was, he was hit with the heaviest of the crane components, 25,000 pounds, smashed his body, causing discoloring injuries. He also had...
Right, and Ms. Beauchamp had a bus on top of her weighing a comparable amount, or not exactly comparable, but from her perspective, it crushed a good part of her body, and why shouldn't that be a good comparator?
Well, he was doused in diesel fuel, he couldn't breathe, he was choking, he was vomiting. I mean, there are some distinctions there.
I'm not suggesting that we increase the award to be $7.5 million for every 3 hours that she suffered. But why isn't that, if he was awarded by this court $7.5 million for 3 hours, why is the award that she received of $25 million for past pain and suffering out of line?
Well, because I think what is different about that case is actually something that this court actually said in its decision. It said, this court noted that there are no similar cases that present such a confluence of facts, catastrophic injuries leading to death, and egregious wanton disregard for the potential loss of life and property. There was a punitive element in that case that is not present here.
Really? There's not a punitive element here?
A punitive element? There's no punitive damages here, and this was an accident. The other one, there was disregard for the crane, and there was a whole punitive piece of it, and there was a punitive award. So there was a different analysis that it appears that this court underwent.
Counsel, Yvonne Y. seems to me fairly analogous. It was a burn case, but the burns led to the extreme chronic pain, which is also prevalent here. And in the Yvonne Y case, also, the patient, the young person, was put in a coma, which happened, medically induced coma, which happened here. Numerous operations and terrible sequelae from some of those operations is another commonality with this one. Obviously, a younger person in the Yvonne Y case, but, and then the psych problems as well are similar. The psych problems that are prevalent here and also Yvonne Y was 2021, which is fairly recent. Why isn't that our datum point?
Because I think you have to take burn victims differently. The disfigurement, the bodily disfigurement, I think burn victims they're just a separate entity, the way
The
that.
pictures that we saw of Ms. Beauchamp's leg, that is significant disfigurement.
I'm not disputing.
It's just a different, caused by something different, but it's no less disfigurement.
I understand, but if we're looking at comparable cases, the way that, for example, asbestos cases only cite 2 asbestos cases, when we talk about mesothelioma cases, which are cited throughout the brief, if you look at mesothelioma cases, courts only cite to those cases when they're comparing pain and suffering, loss of services. Traumatic brain injuries are also different types of cases because you have a cognitive and you have a physical injury.
Take the point, counsel, and you can expand on that if you wish on rebuttal.
Thank you.
Good afternoon, Your Honors. Ed Cooper, Torgan Cooper and Aaron for plaintiff respondent Aurora Beauchamp and Saul Beauchamp. There are no analogous cases in New York State or in the United States of America that someone's had their entire lumbosacral plexus of voles literally ripped off of the spinal cord. And why that's important is what it does to the person. It's not only the function that it affects, it's also this pain complex that's never been seen in other cases, really. I know in a lot of orthopedic cases,
So that's what gave rise to the complex regional pain syndrome.
Exactly.
And that's not just a feeling of non-feeling, but in fact a feeling of constant pain. Is that right?
8 out of
Is that what the
9.
record shows, counsel?
Yes. 8 out of 9 out of 10. And she said they tell me if I say 10, I have to go to the emergency room.
And this requires continuous pain medication.
Opioids every day. But the real horror of that, and this is, by the way, undisputed. They say, oh, it's a runaway verdict. Their doctors didn't disagree with any of this. They didn't come on and say, oh, no, this is that. No one's in 8 to 9 out of 10 pain 24/7. They didn't disagree with any of it. They agreed with everything that was put forth. And the thing is, the real horror of it, when that's chronic regional pain syndrome on top of it, it's sending constant pain signals to her spinal cord, is the only thing that might help is a spinal cord stimulator to stop those pain signals from going to her brain. That's the only thing that they could possibly do for it. And think about the hopelessness that it's the other wound, ironically, her good leg, that's keeping her from getting that.
Right, because of the condition of the right leg, it's not possible.
Scheduled it in 2020, they were going to do it. It was only canceled because of COVID.
So as I read the record, it appeared to me that her condition was worse by the time of trial than it was a year after the incident.
Absolutely.
Am I misreading it?
No, that's absolutely correct. The nerve injury, and it's her entire leg. Originally, there wasn't a flicker below the knee, and then the whole leg was profound weakness. But the pain, see, the complex regional pain syndrome develops over time.
So essentially, this is something that gets worse over time.
Exactly.
All right. So is that what takes it out of the realm of even the Yvonne Y case?
Exactly. It's like being in acute pain 24/7. It's like that acute phase.
So you're saying that the 18 years of future pain and suffering, if she's now a 7, an 8, or a 9, it's just going to get progressively worse.
Yeah, she's just at the max, yeah. I mean, look at, even their doctors confirmed it. They could see her foot red and warm, consistent with early stages of this chronic regional pain syndrome, because that was years earlier. Then the jury sees her leg literally black, because now the vessels have all constricted down, and she's not getting any blood supply to it. So the pain in the future is horrific. And I agree with Your Honor, when we look at the past, we could only look, I mean, the only really factually analogous case would be Kurtage. And to belabor the point, but it wasn't just part of her body that went underneath this bus. It was her entire body. You could see it in the video. It's the front of the bus towards the driver's side, and it's 11 inches of clearance between the undercarriage and the roadway, and she's dragged along the surface. I mean, she breaks 19 ribs, lung contusions, collapsed lungs, hemothorax, neurothorax, 30% mortality just from the upper body injuries.
So, counsel, what case do you say that we have here that is analogous? No case.
You know, the only...
And are you saying, just so that I'm clear, that what the jury awarded was appropriate here?
I am. And what I'm saying is regarding, if you want to look at the past, the immediate stuff, Kurtage would just be a base, the 91st Street crane case. But afterwards, I think what we need to look at, you brought up Giannis, and far be it from me to sit here and say what's worse, to be burned or have chronic pain or to have cancer. You know, that's fodder to try and argue that. I think what the court has to do is look at the human experience, right? That's the only way, because there's no similar cases. So look at the human experience of what the person goes through, their loss of function, their loss of identity, their loss of self. Because even if you look, and I know in the reply papers they bring up stuff like a paralysis case, and I'm not saying that putting down paralysis, I'm making light of it, of course. But you know, there's something in the human will that people, even with paralysis, that they go on and have a functional, sometimes happy life. Human beings are incredibly resilient and adaptive. Aurora Beauchamp can't adapt to her loss of function. So when you see in supplemental appendix page 6, when this religious woman's contemplating taking her own life, okay, she doesn't say, I want to end my life because I'm in a wheelchair or because I can't do anything anymore. She says, I don't want to live. I don't really want to die. I want to be out of pain. It's the pain, I mean, that's just...
Yeah. Can you address the loss of services?
Yes,
past and
thank
future?
you. Thank you. I wanted to talk about this. You know, the only analogous case was the Mafi case, was where, you know, if you were listening to the trial, Saul Beauchamp was really one of the stars of this trial. I mean, his selflessness is incredible. I mean, the person is a 24/7 nurse, caretaker for his wife. He is completely selfless. He does nothing on his own, okay? And that has been 24/7 since the accident. And even if we give them, you know, for in the future for an aid, that takes away that he has to do that service, but it doesn't give him back his wife. It doesn't give him back his lover. It doesn't give him back his companion. It doesn't give him back his soulmate. That person is trapped in 24/7 pain. Her life's never going to be the same. Saul's life's never going to be the same.
Thank you, counsel.
Thank you.
I just want to go back to that unremitting pain, because that is, if you look at Chroma, right? Chroma was an ankle case with RSD and CRPS, and Chroma, the plaintiff in Chroma talks about her unremitting pain. It's a condition, you know, we know that RSD is a condition characterized by severe and disproportionate pain. And in Chroma, there was testimony that ultimately she was not going to have use of her leg because of the pain. This was a woman who decided she didn't want to bear children because she couldn't deal with life itself. So if we're talking about unremitting pain, does it really matter if your pain comes from your leg or from your ankle? Unremitting pain is simply that, unremitting pain. And in Chroma, for a much younger plaintiff, this court awarded $4.5 million in future pain and suffering. So I just wanted to bring that to the court's attention.
Did her pain decrease at all over time?
No, her pain in Chroma was not any better. She couldn't work, she couldn't do anything. And I just wanted to touch on the loss of services. You know, and Mr. Cooper talked about the home health care award. So that's a $4.5 million award for home health care, 24/7. by allowing the loss of services award to stand, particularly for future, you're awarding a duplicative award, because if you're characterizing what Mr. Beauchamp does for his wife, that is what the nature of a home health care aide is going to be doing for her, in part.
There's definitely an overlap. It wouldn't be the same, I don't think.
No, absolutely, because there is. But there are no, even in Hedges, where the plaintiff, the husband essentially lost his wife, not only physically, but cognitively. There was a $1 million past and a $1 million future loss of services award. And I think this court just has to be mindful of, the precedential effect that this case could have.
But I think I guess the question, it seems to me that this is not a precedential case in a certain sense, because no one has come up with any case that's comparable to this in terms of the degree of disability, the degree of inability to function, and the degree of pain for decades to come. So I don't see, it doesn't seem to me precedential in the way that most cases are.
Well, it may not have a specific precedential component. It may not be you cannot categorize it as a burn injury or a traumatic brain injury, but it is still a physical, significant traumatic injury, and it will be one of those cases that people will look to support higher and higher and higher awards. And I think that you have to put it in, and it may be a separate place. It's not a $57 million pain and suffering case. It should be far less. But if this court has no further questions, I will rest on my brief.
Thank you, counsel. Thank you all.
Thank you.
Gutierrez v. 80 Winthrop Street.
Good afternoon. May it please the court. My name is Angelica Arias, and I represent Appellant 80 Winthrop. I ask that this court reverse the lower court's decision and find that Labor Law 240 does not apply, and that Winthrop complied with the Industrial Code Section 23-5.8. As this court is well aware, and probably
Counsel, you go off on the permanent structure argument, which is certainly an argument to make, but here, the permanent structure was supporting the C-rings, as you know, of the scaffolding. And so doesn't that distinguish it from the cases that you cited to us? Also, I should say, and one more thing, which is obviously that it seems that the terracotta that came off was also recently installed by MSR.
Your Honor, it's not distinguishable just because in this case, the only testimony that we have that the scaffold actually broke the piece off is just from the president of the company. We're not even sure that really happened. And even if it did, it has to be foreseeable. We hired an expert to go inspect the wall. That expert said, this is good to support the load. The scaffold—
But it wasn't, because it fell off.
Your Honor, it did fall off, but the expert went to go check and to inspect that it was sufficient, and with that, it wasn't foreseeable that the coping would have fall off. It's not and the court has found that it has to be in areas normally exposed to falling objects. This was not one, and no one was working above the area at the time of the accident. So when the coping fell off, it was part of the building structure. A case that's actually very analogous, I think, is DeJuric, a First Department decision, where there was a pipe saddle that was detached from an overhead ceiling pipe assembly, and the court found that it was part of a permanent structure. In Narducci, again, a Court of Appeals case, plaintiff was removing frames on a ladder when the window fell from the glass.
We talking about Narducci now or Jurek?
Yes, Your Honor.
Narducci, okay, go ahead.
In Narducci, plaintiff was removing frames on a ladder, and the window that was attached to the structure, the court found that it did not require securing for purposes of the undertaking. So in this case, we know—
In Narducci, remind me of the facts. Was the ladder leaning against the glass that fell? And was the ladder coming in contact with the glass that fell?
No, Your Honor, it was not.
Okay, so that's what seems different to me in this case.
Was the terracotta coping part of the scaffold support system?
It was not. The
That's
scaffold.
what the scaffold was affixed to hold it up. How is it not part of the support system?
Correct, Your Honor. But when it comes to the safety device was the scaffold. I think that
The safety device was the scaffold affixed to the terracotta, because that's the only way that the scaffold is going to stay up, is if it's affixed to something. The thing it was affixed to fell, broke apart.
again, we don't know that that was the reason, but as I stated before, Your Honor, even if it was, MSR and AD Winthrop made sure to assure that the wall was going to be sufficient for the load. So if that,
So you say that you had someone inspect the wall. Do we know when that person actually inspected the wall?
we know that the person went before the accident. We don't know the exact date, Your Honor.
How long before? We don't know.
We do not know.
We don't know what the condition of the wall was at the time that they affixed the scaffold to the wall.
Correct. But one would still have to show that the scaffold was inadequate, and the scaffold wasn't inadequate. There was nothing wrong with it.
Counsel, foreseeability is not applicable here, right? Because this is not an accident that involved a permanent structure. It involved a safety device that did not adhere the way that it was supposed to.
I would say foreseeability is applicable because the coping was part of the structure. Even if the scaffold did affect the
A
coping.
part of the structure that it was placed there in order for the scaffold to be utilized.
Yes, but even if the scaffold had ripped off part of it, foreseeability does apply because initially it was part of the permanent structure. So
The scaffold?
No, the coping that injured plaintiff. So the coping that injured plaintiff was a part of the building structure. So one would have to decide when looking at the wall, is this something that would require securing?
But when you affix the scaffold to the wall, you're not expecting a piece of the wall to fall off. It's not supposed to happen, right?
Exactly, which is why I do believe that foreseeability does apply because of exactly what you said. You wouldn't think, oh, when I affix a scaffold to the wall, a piece of coping is going to fall off.
Foreseeability isn't really the question here. The question is whether the scaffold that you constructed was safe, and if it broke off, bringing with it a piece of the coping, which I don't think there's any dispute about, that the coping fell too.
Your Honor, I see my time is up. May I answer?
You can
Yeah.
answer in 30 seconds, counsel.
So the coping that fell off, foreseeability is an aspect of it because one would not assume that if a coping falls off of a wall, you're going to need to have netting, or it wasn't in an area it wasn't in an area normally exposed.
Thank you. You have time in rebuttal.
Good afternoon, and may it please the court. I'm Kevin Kelleher for the third-party defendant appellant, MSR.
Counsel, speak more into the microphone, please.
Oh.
Thank you.
I echo and adopt the arguments that my colleague made as it relates to Labor Law 240 sub 1, but I'd like to address Labor Law 241 sub 6, which plaintiff predicates on an alleged violation of Industrial Code Section 23-5.8b. MSR complied with this industrial code on its face as it's plainly written. In 2013, they hired Dan Siegel, a professional engineer who's licensed to practice in the state of New York. He inspected the parapet and found it to be adequate for the loads that were to be imposed upon it with the hanging scaffold.
How long before the accident? Do you have any more reason to be able to answer that question than your colleague done?
I do not, Your Honor. It's unknown exactly how long before.
And how
but
meaningful is that finding?
Well, when you read the statute 23-5.8b, all of that it requires is that a professional engineer certify that the parapet would be adequate to support the load that's imposed upon it. Prior to plaintiff's accident, in this case, there was a professional engineer. He provided an affidavit in this case where he said that prior to plaintiff's accident, he did go and inspect the parapet. He found it adequate to support a scaffold. The statute does not require that he knows exactly when the parapet was created, when the scaffold was placed upon it. All that it does require is that he inspects the parapet and certify that it was adequate.
But he's able to give a date. He's able to say, on on such and such a date, I went and inspected the parapet and it was adequate to support the scaffold. He doesn't do that.
He didn't do that in this case, no, Your Honor. He omitted a date, but the statute itself doesn't require an exact date of when he actually went and inspected the parapet. All that it seems to require from the plain language of the text is that prior to a scaffold being applied to the parapet, he actually shows up and inspects it and certifies that it was adequate to support the scaffold that was used in this case. And in this case, MSR complied with the statute because we had the engineer. He showed up prior to plaintiff's accident. He certified that the parapet was adequate, and MSR relied on his professional opinion when they made the decision to hang a scaffold on the parapet that unfortunately ended up being inadequate to actually hold the scaffold. But when we're talking about compliance with the statute itself, it seems at face value that MSR
But
complied.
are you claiming that if something doesn't work, but an engineer said before that, oh, that looks okay, that's a defense?
Well, not per se, Your Honor, but
Okay, thank you.
thank you.
Thanks, Counsel. Please.
Good afternoon, Your Honors. May it please the court, Anthony DiStefano for the plaintiff respondent. We cannot divorce the scaffold system from the coping and the parapet wall. In fact, that's not even my contention based on something that my client testified to. That is based on an affidavit provided by the person who was responsible for installing the scaffold. And that person who claimed that they were the designated person on the job site said that he inspected all load-carrying components and means of suspension, including the adequacy of the anchorage and support, the parapet, and the terracotta coping stone. So for that reason, this is not a piece of a building that just simply fell. This is not a pipe bracket that fell. This is a component part of the scaffold that fell and struck my client. And where the scaffold itself contributes to the injury, that is a Labor Law 240 violation. And Narducci is easily distinguished because twice in the Narducci decision, the Court of Appeals made certain to say that the ladder that Mr. Narducci was standing on had nothing to do with the accident. And in fact, they say the ladder had no legally sufficient causal connection to this injury. That cannot be said here because this scaffold did have a connection to the injury and in fact caused the injury. And for that reason, 240 should be affirmed. If 240 is affirmed, obviously, Your Honors do not need to even reach the 241 sub 6 claim. This court is clear on that under the Alonzo case. But if you do reach the 241 sub 6 claim, there are questions of fact. We actually did move affirmatively, and the defendant submitted the affidavit of Mr. Siegel in response, and there is no indication that he inspected the scaffold after the new terracotta coping stone was installed, but before the C channel for the scaffolding system
Who
was
installed that new terracotta coping stone?
That was the plaintiff's employer. And unless the court has any other questions for me, I'll rest on my brief.
Thank you, Counsel.
Thank you.
I would actually like to refer this court to a case of Marin v. AP Amsterdam. Although it is a second department case, it's still persuasive, and I would say that in that case, there was a pipe affixed to the exterior of the building, and the parties had actually placed the pipe improperly. And the court still found that even though it struck plaintiff and it was improper, it still was part of the building, the permanent building structure. So again, even if
What case was that, counsel, again?
Marin v. AP Amsterdam.
Okay, got it.
So in this situation, even if the weight of the scaffold, which again, we are going off of testimony of the president who was not even on site that day, but even if that was the case, it doesn't negate the fact that case law time and time again has said that it is, if it is attached to a building structure, it is the exception to the being hoisted or secured or required securing. So if the court doesn't have any other questions, I just ask that the court reverse the lower court's decision. Thank you so much, Your Honors.
Counsel, thank you all. People ex Rel McGee.
May it please the court, my name is James McGee. I represent the appellant Elvin Maldonado Tejada. I am asking for his release pursuant to CPL 3032A. There were 96 days chargeable time to the people as of December. He's been held illegally ever since. He's still incarcerated.
So, counsel, you were not waiving motions, but you didn't want a motion schedule.
Correct.
What is that? What posture is that?
I asked the judge to put it over for COC. I get 45 days to consider whether or not I'm going to file motions.
To consider or to file motions?
Both. In my case, it was to consider. I hadn't been given any discovery. I didn't know.
Does the statute that requires you to file motions within 45 days of arraignment make mention of discovery?
No. No, and we got to the 45th day, and I didn't. I would have to, and I decided that I wanted time to file motions. I would have at that point asked for an extension. I didn't get any.
Because you already had a motion schedule. When you left from arraignment, you had a motion schedule.
Judge Beller set a motion schedule. I did not request a motion schedule.
But you didn't waive motions either.
No.
Okay.
I have 45 days to decide whether or not I'm going to file any motion.
So where does the statute say that you have 45 days to consider it or 45 days to file it?
It says to file it.
So how do you interpret that to mean that you have 45 days to make up your mind if what it says is you have 45 days to file?
It doesn't set a time for when the defense counsel has to make up their mind.
I'm sorry, but you said it's 45 days to file.
Correct. You have 45 days to decide because you have to file by the 45th day.
Okay, but you didn't file by the 45th day, right?
No.
So what happens if you fail to file within 45 days?
Especially given
Yes,
that
but
the
you
statute
get
specifically says that pretrial motions shall be served, not shall be considered, but
No,
shall be served.
I'm not denying the language of the statute. The judge asked me why I am saying consider instead of file, and the reason is because if you don't file, and to answer Judge Mendez's question, the reason you have 45 days to consider is if you don't, you're precluded.
You're what?
Precluded from making any motions.
So
And that's the risk you run when you do not file by the 45th day. You run the risk of preclusion. It's a decision that you should make with discovery, but don't have to have discovery with your client. And you decide.
In this case, your motion was not, counsel, the court did consider your motion when you filed it December 2nd, or am I mistaken about that?
The court did consider my motion, but the relevant question here is, out of Supreme Court arraignment, is the time chargeable or not? And if I may.
And why is it excludable?
It's not excludable. The time is not excludable. Sua sponte adjournments are chargeable to the people.
But was this sua sponte when she gave you an opportunity to, she said, okay, you're not waiving it, you'll do this in 45 days?
Yes, that's her. I asked that the case be put over for COC, for the certificate of compliance. The people obviously could not could not proceed to trial because they weren't ready for trial. They hadn't filed a COC. The judge took it upon herself, sua sponte, to set a motion.
What the judge did is, in response to your refusal to waive motions, set a motion schedule so that motions could be timely filed.
Motions can have to be timely filed statutorily. The statute 255-20 exists for you to file your motions by the 45th day. Out of the current scheme with 255-20 and 3030 is that time runs until the people file a COC and a COR and get discovery, and simultaneously the defense has to file motions within the 45th day. It is redundant for the judge to set a motion schedule for the 45th day. Motion schedules out of arraignment.
Well, it's not redundant because once your motion's filed, the people need an opportunity to respond, and a judge needs to render a decision because I'm sure if you file a motion, you want a decision, right?
Right.
So that's what the motion scheduling is all about. It's not about redundancy.
Motion schedules can also be filed when the defense says, I think I'm going to need more than 45 days. I'd ask for an
But you didn't say that. You said, I'm
Oh, I
not
didn't.
waiving, but I don't want a motion schedule.
No, I didn't.
Right.
The Judge Bybin found this was excludable under 3034A. 3034A does not apply here. They apply to adjournments from proceedings past, not for proceedings going forward. And pre-readiness delays are excludable only when they have been caused by the defendant for their benefit. I'm going to ask also, Judge, throughout their brief and in their argument in front of Judge Bybin and Judge Beller, the people said that they relied on the fact that this would be excludable and on the motion schedule. I would just ask you, I'd like to know what they were relying on to do or not to do, because I think it's pretty clear that the fact that Judge Beller adjourned this case for 4 months out of Supreme Court arraignment was that the people didn't serve any discovery at all for 3 months.
Thank you.
Thank you.
You have time, rebuttal.
Good afternoon. May it please the court. Franklin Gunther for the people. Your Honors, this court in Garrett.
So I have just to follow up on what your friend was arguing, given that the prosecutor didn't provide any discovery during that time, were there any ramifications for that in terms of excludability or anything else?
No. Our office, well, and if you look at the transcript from the habeas hearing itself, apparently there was a misunderstanding about sort of whether we had actually provided a link for the discovery. But I think the discovery issue is sort of irrelevant to this because...
Well, it's not irrelevant, right? Because you have, and you being the people, have an affirmative duty under the statute to comply with discovery and file a certificate of compliance before you can state ready to move forward.
Correct, yes. It is relevant in the sense
It's
that,
very relevant.
correct, in the sense that we need to be ready for trial by a certain time, and also there's a separate statute that gives us a deadline to do that. But in terms of whether 3034A applies, I don't think the separate discovery statutes apply, because once the court says, interprets the statements of defense counsel at arraignments and says, all right, I am taking your, let's say, inability to decide at this point whether you're going to file based on the facts of the case and what we know from the complaint.
What your adversary is saying, that the request was for the court to put the case over for a certificate of compliance, and we both know that many courts do that from time to time, but the court rejected that request.
Well, and I would just again say that that's on a separate timeline. I mean, obviously it has to be done before we can declare ready for trial, but 255.20 provides the deadline for us to do that. And so just looking at whether the...
Well, the follow-up is that what your adversary is saying, if I read the papers correctly, is that there was this level of prejudice by not having discovery before having filed motions.
Well, first of all, I don't think that the actual motion itself bears that out. I think if you read the motion papers, they're all very, they address issues that, first of all, didn't require any discovery at all. And we know from the complaint that this is a car stop case involving drugs found in a bag. And so you can kind of already see just from the complaint the kinds of issues that will become relevant in pretrial filing.
I know,
Also,
counsel, but we're setting a rule for all kinds of cases here. And we don't want to create perverse incentives for either side to engage in any kind of game playing with respect to the schedule.
No.
So is there an asymmetry that she directed Justice Beller, directed the people to file their COC as soon as possible, but the defendant had a deadline?
It's certainly not in this case because, in addition, the defense didn't meet that deadline, and there was no preclusion from him filing his pretrial motions in December.
So the 4-month period, I'm sorry, go ahead.
I have two questions. Number one, can they file a motion before you serve a certificate of compliance?
Yes, they can. And they can, yes, and they can also indicate that, you know, and the motion papers in this case do say that. They say, you know, there are facts that are unknown at this time, and pending, you know, receiving more information or discovery pursuant to the people's schedule, we will file more motions.
Second question is, can the court order a motion schedule with or without the defendant's consent?
Yes, we would say under 255.20. And again, just based on the representations that the counsel is making at arraignment and the facts of the case, and this is what the habeas court held, is that everyone's reasonable assumption was that if you're not waiving motions, you're going to file motions by the end of the 45th day. And getting back to whether the exclusion applies, that is tracks to the language of the statute, that there's a reasonable, basically a reasonable expectation that, okay, well, if defense counsel has not decided whether they're going to file motions, we don't have to be ready until we have gotten an answer on that one way or another.
Wait, what?
Well,
The people don't have to be ready until you get an answer from defense counsel?
if there's an expectation of everyone, the parties in the court, that pretrial motions are going to be filed, and this is what this court has said in Garrett and Green, is that the people shouldn't be expected to be ready for trial while there is still a
Right, but you know you have this corollary obligation to provide discovery within a certain time under CPL 245.
Correct.
Right? That has nothing to do with defense counsel's timing to file motions.
Correct.
So you can't just sit back and do nothing in the 4 months, right?
No, I think that's accurate, and I
But
think
what you did is you got the cover of the 3030 motion practice exemption and did nothing in the 4 months.
well. And again, I think I would go back to the habeas hearing itself. Actually, the record indicates, and I think the court credited this, is that we had attempted to provide discovery, and for whatever reason, the link was broken, or there was just a misunderstanding about whether the discovery had been provided.
The 1986 Court of Appeals case, Medarix, that defense counsel cited, how is that applicable to the facts that we have here, especially given that it's from 1986?
It's not applicable here, and I think this, first of all, goes to the structure of the statute. The consent provision under 4B is distinct from the pretrial motion provision under 4A. And I think the way that this court should interpret it is that basically, all else being equal, the defendant can waive certain adjournments. But I think in this case, because you've got that pretrial motion schedule pending, and again, the people's expectation is, all right, well, there may be a motion filed sometime between now and October 24th. Therefore, that exemption applies irrespective of whether he consents to it or not.
Can we say that the setting of the motion schedule was a sua sponte adjournment of the matter?
No, and again, under Meredith's, I'm going to butcher that name, but under that case, there was no other basis for an adjournment at that point. The defense attorney had pointed out that there was some jurisdictional insufficiency issue with the indictment. No one had asked for more time or asked for an adjournment to file a motion. The court just said, all right, well, we're just adjourning. Here, because the court has set a pretrial motion schedule based on counsel's representations, now the posture is pretrial motions.
But counsel didn't request a motion schedule, and counsel has specifically stated that over and over again.
Correct, but I think the court, and if you look at the transcript, what the court says is, if you're not waiving motions, then I'm interpreting that as you're reserving your right to do so. Now, counsel could come back in a week and say, you know, Judge, I've spoken with my client and we've decided we're waiving pretrial motions. Now we're in a different posture where the people can't expect that sometime between arraignments and whatever that 45-day mark is, that motions are going to be filed. But as long as counsel is holding open that possibility, and based on the facts of the case where you have a car stop, you know, there are plenty of motions that can be raised with no discovery at all, and that can always be supplemented once we do file that COC and hand over any relevant discovery that might pertain to those issues. And so, again, this court should construe the statute in line with its decisions in Garrett and Green. And unless there are questions, we ask that you affirm.
Thank you, counsel.
Thank you.
Just to clear up the record, the ADA never sent the email. She said that she thought she had and didn't, not that a link was broken, just to clear that up.
Counsel, what is your view of the relevance of the 1986 Court of Appeals case, Meyer?
It's a sua sponte adjournment. It's a sua
So you think it's still relevant, notwithstanding the current discovery statute?
Yes. Sua sponte adjournments are chargeable to the people. I didn't ask for this adjournment. I asked for time to be charged. That's important. I asked for time to be charged. That is the objection to the motion schedule.
And what about counsel's argument that you could have come back in a week and said, we've discussed it and I am not going to file any motions.
I have 45 days to do that. I have 45 days to have that decision and to think about it and to consider the discovery if I have any, but to talk to my client, make sure he's aware of the fact that we may not win a suppression hearing. It might not be worth the time. You're in a lot of trouble here. Maybe our best shot is 30-30 to think about this, to talk to my
Counsel,
client.
one of the things that you just said here is that, I didn't ask for a motion schedule. So I asked for a specific type of adjournment. Is that the way court parts run? Like whatever reason defense counsel asks for the case to be adjourned for, that's what it gets adjourned for?
Out of arraignment, there are a bunch of different things
I
happening.
know.
Right. So in this case, what normally happens is I understand that the defense isn't waiving time and are asking for a consent motion. I'm going to set a tentative schedule. Please get discovery to the defense, and if they don't file within 45 days, they preclude motions. That's what generally happens.
But can the court schedule, set a motion schedule? Like as the court did here. I mean,
She can
there's
set a
reason-
motion schedule. Absolutely.
She can.
The question isn't whether she can set a motion schedule. The question is whether the motion schedule she sets is excludable under 4A. It is not. It is not. And if this court finds it, it is going to effectively give judges all over the state 45 days, the power to unilaterally give the people 45 days before any discovery is filed at all. And that, and especially...
Isn't that a power that's already statutorily there, given that you are required to file your motions in 45 days if you choose to file motions?
No. No, the way 45 days runs out of 255-20, that's the defense's consideration. 30-30 runs out of arraignment, that's the people's consideration. They both run at the same time. What Judge Beller did and what Judge Bybin agreed with was effectively, I can cancel one and not the other, and that is not what the case law says out of the Court of Appeals.
All right, thank you, counsel. Thank you both. Slovakis v. Royce Poyatis.
Good afternoon. Your Honor, may it please the court. My name is Mario Biaggi, and I seek to vacate the June 6th decision for 3 reasons in which the sanction was awarded.
Definitely, counsel, 3 of us were here last time you were here.
Yeah.
In the October decision
Right.
that Justice Bannon issued, she did say plaintiff's counsel shall pay, and then the judgment, of course, did not reflect that accurately. But that was her order. Everybody knew that was her order. So why shouldn't she have been allowed to correct this?
Because it was supplemented, Your Honor, in the November 8th.
It was what?
It was supplemented in the November 8th decision in which the award was not to plaintiff's counsel, but to plaintiff. And these decisions were before the court when determining the validity of the sanction issued in the first instance. And when the court rendered its decision on June 24th, it had those decisions in front of it and specifically said in 3 separate instances that it was the plaintiff, not plaintiff's counsel.
But why would the plaintiff be required to pay for what counsel did, for counsel's frivolous actions?
Well, the appellate division should then, if that's the case, the appellate division should have said previously that it was the plaintiff's counsel that was responsible, not the plaintiff. And in that regard, the defendant should have made a motion to re-argue the plaintiff's decision. So that's already been determined in the law of the case, and it's in black and white in that regard. And that's...
Well, the black and white of it all is that the order said that plaintiff's counsel is to pay the fees.
No. The order said plaintiff is to be sanctioned. The supplemental order said that. In the first one, it was both. And then it changed in the supplemental order, and so you had a decision by the court to say, okay, we've changed it to the plaintiff is responsible for that.
It's not changed, it's clarified.
Supplemented, whatever the case may be. The final order was the November 8th order in which it said the plaintiff is responsible for this. And then we
That brings me back to if it was clarified that plaintiff's counsel is to pay for plaintiff counsel's frivolous conduct, Why are we trying to put this on a plaintiff?
Well, there's significant reasons for that, okay? The first order of business is that the appellate division has already decided that, and that's the law of the case. The appellate division perhaps should have said
It
plaintiff's
wasn't in
counsel.
front of us. What was in front of us was whether something frivolous happened, not who should pay it. I don't think.
Well, I mean, then the decision didn't say that. So that's the law of the case as far as the decision is concerned.
Okay.
Well, if it didn't say that, right, and it only talked about whether conduct was frivolous, then it can't be law of the case that plaintiff was to pay this sanction.
Well, it said that in this decision. The decision specifically said it was the plaintiff that was responsible. So the second reason is the attempt to change that also occurred after the appeal had been perfected. There was no jurisdictional basis for that lower court to change it after the March 17th perfection of the appeal. And that
Are you
decision
raising
was
that
entered-
argument for the first time on this appeal?
I'm sorry?
Are you raising this specific argument for the first time on this appeal? The
On
one
this-
about absence of jurisdiction. It seems to me this is the first time you're raising it
Yeah,
on the appeal.
it's the first time it came up. It's the first time it's relevant because that decision occurred afterwards.
All right, thanks, counsel. You got time in rebuttal.
Okay.
May it please the court, my name is Anthony Dock and I represent the defendant respondents. Three orders that are in play here. The October order clearly stated that my friend here was responsible and obligated to pay for the sanctions being I had to bring a motion to vacate a note of issue that was filed that he wasn't supposed to. He violated two orders. Plaintiff didn't violate the order, counsel did. Despite the fact that he had two lawfully judicial orders, he chose to ignore it. That was counsel's mistake. We had a hearing October 17th by way of order show cause. It was clear, and the judge was clear in his decision. There was no counsel or plaintiff. It was clear in her October order, plaintiff's attorney, Mario Biaggi.
So you heard
is
his
responsible.
argument that the November order sub silentio changed that.
And we've taken the position it was Scrivener's error. It was clearly a clerical error because it's inconsistent, and that's a supplemental order. The supplemental order came about because we were granted our motion for sanctions, and the only question is reasonable attorney's fees, which was presented to the court. That's the November supplemental order. It was inconsistent with the original October order. The judge amended that order, and the trial courts have discretion to amend an inconsistent order, so long as substantive rights have not been affected by the parties. This is not about the parties. This is about the conduct of an officer of the court who violated two lawfully judicial orders. With that, I rest.
Thank you.
Correct procedural format would have been to move to re-argue to that decision. And it's not a Scrivener's error, it's the changing of a party. But I want to tell this court, to be very clear, I've been doing this for 4
The obligation from you to your client, and you're continuing to hold your client responsible for something that you've done, right?
Well, it's a consistent argument, because if I vacate the order, then I could protect my client's interests because they elected a remedy that's the wrong remedy for them to do. And
You were told by the court not to do that, and you did it anyway.
Do what?
Nothing.
Okay, I just want to be very clear that the underlying sanction, if we look at it, there were 12 orders that were violated by the defendants in this regard. And the last note of this,
That's way out of line.
Yeah,
Just
but-
stick to your argument.
Okay, my argument then procedurally, Your Honor, is that you can't enforce that order because it's for the reasons that I've stated. It's a jurisdictional problem. It had been perfected. They can't do it after the fact. The law of the case very clearly said that it was the plaintiff, not the plaintiff's counsel, to do it. You can have the arguments you want now, is fine, but that's the law of the case. And the third issue is with respect to if they wanted to change the supplemental decision in November 8th, then they should have made a motion to re-argue. My client knows what's going on here with respect to this process. He's totally okay with it. He believes like
Are
I
you
believe.
saying that Judge Bannon has no power to correct mistakes, Scrivener's errors on prior orders? Are you saying that?
I'm saying that it's not a Scrivener's error to change a party who's responsible for a judgment.
The party, it was changing it from mistakenly from party's counsel to the party.
Well, that's an individual. Maybe I shouldn't say party, but you change it from one
You're not
individual.
a party, you weren't a party in that sense.
You change it from one individual for another. My position is that that's not a Scrivener's error. She didn't have jurisdiction. The underlying sanction, I've been doing this for 4
But
decades. and-
she did sanction you, right?
No. She sanctioned both parties and changed it to put it to the plaintiff. And then they, by letter application, said it's not the plaintiff, it's the attorney, because they're trying to build a wedge between myself and my attorney. That's what the tactic they've taken.
One could think.
It's not
that
very
if you
fair.
have to- If you are seeking to change the obligation from you to your client, that one might see that
Let her
as
finish
you're
the
putting a wedge between you and your client.
No, actually, I'm not. My client knows what's going on. I'm seeking to vacate the judgment and then be able to take the posture that they've elected their remedies, and that because they've elected it, they can't go against my client either. And if you, respectfully, if you think that I'm acting in good faith, and I haven't done this, like I said, I haven't been sanctioned for 4 decades or anything like that, should have some credibility in terms of the process, that these are legitimate arguments, and they protect my client at the same time while protecting what I think is an appropriate jurisdictional issue. You may not like that, but because of whatever feelings you have, but that's the law of the case.
Not operating on our feelings, counsel.
Nope.
Okay.
Thank you, counsel.
Thank you very
both.
much. Thank you.
Matter of Bulgari. Please.
May it please the court. David Bomdad, Meltzer, Lippy, Goldstein, and Brightstone LLP for the respondent appellant Ilaria Bulgari.
Counsel, let me ask you a housekeeping question first. What, as of today, is the status of the federal court case?
A trial has not yet been conducted, Your Honor.
Is not.
It has not been conducted.
Do you have a
Your Honor.
date?
I do not have a date. Mr. Carlin is counsel of record for his client in that, and I do not believe a date has been scheduled.
Please continue.
Thank you. The portion of the surrogate's court's decision awarding Veronica Bulgari a refund of more than $1 million from Ilaria's trust should be reversed for several reasons. First, Ilaria was never provided an opportunity to oppose or respond to the affidavits of legal services in any way whatsoever, and no hearing was held. Second, the court did not consider, and the decision makes clear, the court did not consider more than $4 million of legal fees that it implicitly approved in its decision. Third, it awarded...
At the moment, I mean, because the federal action is still pending, and it survived, some of the claims for breach of fiduciary duty survived summary judgment, right?
That's correct, Your Honor.
So also that could result in, I take it from your argument, that Veronica would have to pay the fees herself rather than...
That's correct, Your Honor. That's exactly our argument, and we didn't have the opportunity to even present that to the court because what's required under the refunding agreements is that proper charges for the trust be refunded. If she was defending herself and it's found that she was defending herself personally, individually, and not acting in the best interests of the trust, those are not proper charges to the trust, and they are not required to be refunded from the distributions that were previously made. In any event, third, the order awards $2 million more than Veronica purported to even incur in legal fees. The invoices that were purportedly approved contain heavy redactions, vague time entries, block and double billing as well. And also, to Your Honor's point, it's premature because we don't know whether Veronica was acting, again, in her own self-interest or protecting the trust. Now, there are many cases that show that a hearing is required, regardless of whether a refund is ultimately awarded or not. A hearing is required to determine all of these factors and make sure that whatever is being refunded and being sought by the trustee is proper. This court in Cumble v. Windsor and also in Bankers Federal Savings Bank, which again involved much smaller fees, in one case $3,000, in another case approximately $95,000, reversed because one party was not given the opportunity to oppose the affidavits of legal services, and the court held that a hearing was required in order to be able to approve those fees. There's also a case...
In your brief, you say that the propriety of the legal fees can't be determined until the conclusion of the trial in the SDNY. So why shouldn't we just stay at this point?
I believe that it should be reversed, remanded, and held in abeyance until that is completed so that we know whether or not they are proper legal fees or not. That's exactly our point, Your Honor. That's what we believe should occur here. In Lehman Commercial Paper also, the facts are actually very similar to here. In that case, the third department reversed an award of only $80,000 because no hearing was held and the defendant was not afforded an opportunity to challenge the reasonableness of the fees. The legal fees were insufficient in light of block billing, vague and redacted time entries. The court was unable to determine the necessity of the services rendered and the benefits achieved by the legal fees that were incurred. And the court didn't provide a clear and concise explanation as to why it approved the fees. We have almost all of those same facts here. There was no hearing or opportunity to oppose the fees. There's block billing, vague and redacted time entries throughout all of the affidavits of legal services. The court was unable to determine the necessity of the services, again, for the very same reason. There's pending litigation, and we don't know whether she will be found to have breached her fiduciary duties, in which case those legal fees we would submit are not proper legal fees and should not be charged to the trust. And the court has not provided an explanation as to why the fees were even approved. All it simply says is that Mr. Carlin has demonstrated that the fees and disbursements were commensurate with the services provided, the time spent, and the trust assets. It doesn't actually explain why the fees were necessary, proper, and approved. And this court has held in
They
Bankers...
do make this argument, your opponents, that it's more like specific performance on the refunding agreement. Like it's a contract. They're getting damages for a breach of contract by Ilaria. You want to respond to that?
Absolutely, Your Honor, and thank you very much. That's the argument that they're making, and they're making that argument now for the first time on appeal. It fails for two reasons. One, the court's decision makes clear that it is approving legal fees. It goes through the factors that are set forth in matter of Freeman and matter of Potts, which goes through the reasonableness of the fees, the experience of the attorneys, the complexity of the issues, and so on. It actually says explicitly in there that it is determining that the fees were proper and legitimate expenses of the trust. After it goes through that analysis, even though that analysis is very brief. And also, it's not alleged in their petition. That's not the relief that they ultimately sought. Their petition goes to great lengths to justify why these legal fees were required and why they were justified in expending that time. And in any event, we submit that even if it was a breach of contract argument that they were making and that was the claim that they put forth, there is no breach, and we cannot determine the breach or the damages as a result of the breach until we determine whether these are actually proper fees attributable to the trust. I'll reserve my time for rebuttal. Thank you.
Thank you, counsel.
May it please the court, Mitchell Carlin, Gibson, Dunn, and Crutcher for the respondent, Veronica Bulgari. Your honors, there was no fee award below. This is not an appeal from an award of legal fees. The appellant, Ilaria, will have today, tomorrow, or whenever she wants to, the opportunity.
Sounds like it though in the surrogate's decision, and also you're saying that the disgorgement, or whatever you want to call it, is justified by, quote, voluminous, overbroad, irrelevant, and harassing discovery that has been imposed on your client by Ilaria. So that sounds like attorney's fees. Like you want compensation for having to fight this litigation.
The law firms were not the move-ons below. The trustee filed a petition, which is in the record, obviously, and which is entitled Petition to Compel Refund Pursuant to Receipt and Refunding Agreements. The petition itself uses the word breach, uses the word violation of their promises. The other two beneficiaries of the estate, of the trust, did honor their promises and did refund the money when they received the refund request. The monies, the $40 million that Ilaria received, would never have been distributed to her under any circumstances had she not signed the refunding agreement, because the trustee has two competing obligations. One is to make timely distributions when appropriate, and the other is to retain enough money in the trust to administer it.
Well, there are other fiduciary duties as well for any trustee.
Judge.
And here, just using that as a premise, here there's an allegation, there's a federal lawsuit that has survived summary judgment alleging that...
Forgive me for speaking over you, but only a small piece of it has survived.
Okay,
The vast majority of the claims have been disposed of on summary judgment. I'm sorry, Judge.
You know, but we all know what things can happen at trial as well, and complaints can be amended, and who knows? Anyway, there's a piece, even if it's a small one, alleging breach of fiduciary duty.
Yes, Judge.
In the Southern District of New York.
Yes, Judge.
So shouldn't we wait at least to
Judge.
see what happens?
No.
Okay.
Because the settlor of this trust 20 years ago set up an architecture. And if, with respect, the surrogate found, as a matter of fact, and it is not denied, that the trust is out of money, that the trust does not have enough money to administer itself. The federal lawsuit in question was filed 3 days after the final distribution of the $40 million. It was obviously Ilaria's intent all along to do that, and she kept that secret. And the trustee would have reserved for herself a lot more than the $2 million that she reserved for herself had she known that Armageddon was coming down the pike 3 days after the final distribution was made. But the bottom line, I see that my white light is on, respectfully, the only point, respectfully, that anybody needs to focus on, I respectfully suggest, to decide for an affirmance here, is that Ilaria has not lost anything. She has the right under this statute to make an application to the surrogate's court now or at the end of the case to have all of the disbursements and expenses of the trustee reviewed. The statutes provide that if any creditor, like the law firms that the trustee has engaged, is found to have received more than they should have received, either because the fees were too high or whatever, that money, the surrogate can order that money to be paid back. And so
it's just a little hard for us to go around her election of remedies, that's all.
Yeah, is there a hearing at that point?
Yes.
When there's...
I'm sorry.
No,
yes, of course. Mr. Bamdad is of course correct that a final ruling, which I respectfully suggest hasn't happened yet, that these firms are entitled to be paid in full or in part the bills that they have submitted. Of course, that he will be entitled to a hearing, he will be entitled to cross-examination, he may be entitled to discovery, I don't know. But yes, I'm not denying that if this were being, if I thought that this were, if the surrogate thought that this were a final award of legal fees, and that's it, where there's no more chance to revisit anything, everybody's rights are now waived forever, Mr. Bamdad would be right.
What?
He'd be right. But that's not what happened. That's not where we are. That's not the posture of the case. We are conceding, as we must, that at any time under the statute, he doesn't even have to wait, she does not have to wait until the conclusion of the case. She's free to wait till the conclusion of the case, but she doesn't have to. She can ask the surrogate now or at the conclusion of the case to revisit any disbursement from the trust that the trustee has made and make a ruling about it.
Thank you, Counsel.
Thank you, Judge.
Your Honors, I'd like to address a few things that Mr. Carlin just said there. First off, he talked about how the other beneficiaries of the trust has refunded the money, and somehow that means that Ilaria also has to refund the money. Whether they refunded the money or not is not determinative as to whether it should actually be refunded and whether it's required under the agreements. Second, he argues that the trust does not have sufficient assets to administer itself anymore. Again, our entire argument is that we don't know whether these are actually expenses of the trust or not, and that cannot be determined at this point. And third, and most importantly, I think, to Mr. Carlin's point, I appreciate that he is conceding the fact that we can try to challenge these legal fees at a later time, but that's not what this decision allows. This decision goes through an analysis of the different factors that relate to the approval of legal fees. It reviews the affidavits of legal services, albeit only Mr. Carlin's, and not the Cat and Muchin firm, who also submitted affirmations of legal services. It states, Veronica has submitted affirmations of counsel attesting to the legal fees and expenses incurred by the family trust, which established the following, which I explained earlier, that it goes through that Attorney Carlin has demonstrated that the fees and disbursements are commensurate with the services provided, given the issues raised and the complexity of these matters, the time spent, the trust assets. And then it goes on to say, Quote, Veronica has established that the legal fees and expenses incurred by the family trust were proper and legitimate expenses. That does not mean that this is an issue that's open to have a hearing at the end of the accounting proceedings. It is determining that they are proper and legitimate expenses of the trust now after analyzing the legal fees and the affirmations of legal services that were provided by them. And with that, we rest on our briefs if your honors don't have any questions.
Thank you, counsel. Thank you both.
Thank you.
ARK 448 Doe v. Marino. Please.
Good afternoon, Your Honors. Nahid Sheikh from Jeff Anderson and Associates on behalf of Plaintiff Appellant. May it please the Court. Just like in every other New York negligence case where the cause of action accrued outside.
Put the microphone a little closer, please. Thank you.
Is that better?
That's better.
Just like in every other New York negligence case where the cause of action occurred outside of New York, the trial court here should have applied the borrowing statute, CPLR 202, to determine whether or not plaintiff's claims were timely. The trial court failed to do that here, and without a doubt, under CPLR 202, plaintiff's claims are timely. Under CPLR 202, when a cause of action accrues outside of New York, a court is first required.
Are you no longer pursuing your claim under the Child Victims Act?
This is a Child Victims Act case, but the Child Victims Act was just, it purely dealt with time limitations. So
I'm aware of that.
Yeah, so the case is being brought under the New York Child Victims Act, and every New York Child Victims Act case that deals with a cause of action that accrued outside of New York discusses the application of CPLR 202.
And in all of the cases that have been held, all of the cases that occurred outside of New York State that involved the Child Victims Act involved plaintiffs who were residents of New York State, correct?
Correct, except
so your client is different, right?
My client is different, but the analysis remains the same.
Is there any case where the victim was outside and the abuse outside of New York and the abuse took place outside of New York?
There is a case, that's the SH case, but the difference between this case and the SH case is that in SH, the court compared the statute of limitations of New York with the statute of limitations of Florida, where the cause of action accrued there. And the statute had run in Florida, so plaintiffs' claims were not timely. Here, plaintiffs' claims in New Jersey were timely.
The SH case, is that a second department case?
That is, Your Honor.
In that second department case, didn't the court expressly determine that the legislative history supported a finding that the legislator intended it to provide relief to New York residents only?
Although the court does acknowledge that the legislative intent is to benefit New York residents.
Acknowledge or specifically express that claim?
Well, the court specifically says that application of CPLR 202 may make it so some non-resident plaintiffs can bring their claims under the New York CVA, but it never explicitly says that a non-resident of New York cannot bring a New York CVA claim.
The intent of the legislation was to benefit New York residents.
Well, the New York CVA's legislative intent is also to hold a New York institution liable for its wrongdoing. And here, Maryknoll was a New York institution.
Wrongdoing that inured to residents of New York State.
To any resident. This is no different than any other negligence case where CPLR 202 should have been applied. And what that requires is that the trial court should have compared the statute of limitations in New York with the statute of limitations in New Jersey, where the cause of action accrued, and they would have found that under New Jersey law, the claim was also timely, because New Jersey similarly enacted a Child Victims Act case, the New Jersey Victims' Right Bill, that opened a 2-year legislation to bring otherwise time-barred claims.
Why wasn't this claim brought in New Jersey?
Because New York is a proper venue here. Maryknoll is a New York entity that's been operating in New York.
But all of the conduct happened outside of the state, and the plaintiff is not a resident of New York State.
The decisions that go to the heart of plaintiffs' negligence claims, the actions and inactions of Maryknoll occurred in New York. Brother Ed, the perpetrator here, was employed in New York, and he traveled from New York to New Jersey to abuse my client. On the underlying motion to dismiss, the trial court's analysis should have started and ended with application of CPLR 202 to determine whether plaintiff's claims were timely. No other analysis needed to be undertaken here. All of the cases that the trial court relied on concede the fact that CPLR 202 should apply to a New York Child Victims Act case. If your honors have no other questions, I rest on my papers.
Thank you, counsel. You have time, rebuttal.
Good afternoon. My name is Claudine Weiss. I represent the respondent defendant.
Is this statute limited to New York residents only?
The New York CVA, underneath the legislative intent, is applicable only to New York State residents only. In fact, the legislative statement, which is outlined in SH, states New York residents alone.
So the fact that this particular defendant happens to be a New York resident, because the plaintiff is a resident of New Jersey, then the plaintiff should not be able to bring this action here?
That is our contention, Your Honor. Not only that, quote unquote, Brother Ed is an unknown individual. He's not been identified as to know who he is at the time that this conduct allegedly took place in or about 1960. But each of the cases that have been put forth, both in the first, third, and the second department, state that the New York CVA is only applicable to New York residents, regardless of where the conduct may have taken place.
Is there a public policy behind the reading of the statute in that way?
I think the policy reasons is that every jurisdiction is entitled to prosecute conduct within its own borders. New York State wanted to take the position that it was going to afford the policy position that it was going to protect its residents within its borders. New Jersey.
When you say protect its residents, you mean having this open up the statute of limitations for claims that might not otherwise have been able to be brought now that they're able to be instigated, right?
Correct, Your Honor.
So counsel, why shouldn't, assuming we agree with that analysis, why shouldn't we apply the borrowing statute here?
The borrowing statute is not one that should be applicable in this matter. We're dealing with a New Jersey resident. We're dealing with a New Jersey conduct. It doesn't afford itself to allow New York State to adopt the New Jersey CVA statute to afford the plaintiff in this matter additional time. The CVA statute for New Jersey, I believe, is statute 477. It opened up the timing for individuals up to the age of 55. Based on what we know, without knowing the individual herself, her date of birth would have been in or about 1948, placing her age at the time of the filing, the complaint at 73. So the case should have been brought in New Jersey. It could have been brought in federal court. However, it was brought in Supreme Court. The underlying decision by Judge Tisch was appropriate and should be upheld. Thank you.
Thank you, counsel.
In the underlying papers, Marino conceded that CPLR 202 was the proper analysis, but they misconstrued the New Jersey time limitations there. Setting that aside, CPLR 202 requires that when a cause of action accrues outside of New York, the court is required to first determine whether the plaintiff is a resident of New York, and if it's not a resident of New York, it requires the court to then determine whether both of the time limitations have not expired, essentially. Here, if this court applies the same analysis it applied in Samuel W., and the second department applied in SH and Smith v. Procamps, you will find plaintiff's claims timely. In Samuel, this court acknowledged and applied the correct CPLR analysis, but plaintiff was a resident of New York. So this court didn't need to get to the comparison of statutes of limitations. Here in Samuel, also, this court acknowledge that, of course, the New York CVA is subject to CPLR 202. There's no exception here for a CVA claim. With that, I rest on my papers.
Thank you, counsel. Thank you both.
Thank you. That's you.